Good morning, everyone. Thank you for joining us today for this webinar for case managers. We're holding the webinar this year in place of our annual case managers training day due to the COVID restrictions. Today we're going to be talking about three topics. First up, I'll be talking and just giving an update on some legal issues that have occurred over the last 12 months. Then Claire is going to talk about changes in practice and procedure since the lockdown. And finally, Warren is going to talk about medico-legal and case management assessments post-lockdown. Today's webinar is going to be for 45 minutes. And Claire, Warren and I are each planning to talk for about 10 minutes each, thus giving an opportunity for questions. So there is a Q&A box at the bottom of your screen. Please feel free to ask any questions and hopefully, time permitting, we'll be able to answer them. So I'm now going to share one thing I forgot to mention is at the end of the seminar, to entice you to still continue listening, we're doing a prize draw for a bottle of, a magnum of champagne. And I'm now going to share my slides with you. So the first thing I wanted to mention was that on the 17th of July, the new Ogden tables were published. Most of you will know that the Ogden tables are the tables that personal injury practitioners use to calculate claims for future loss in personal injury claim. And these new tables take into account some updated data from the Office for the National Statistics that was published at the end of last year. They show that life expectancy hasn't actually increased in the level that the previous statistics had shown would take. And this, in fact, means that there is a modest reduction to future loss claims when using the new Ogden tables. And I've produced a table here just highlighting the difference between the old Ogden 7 and the new Ogden 8 tables. Next, I wanted to mention anonymity orders and the recent case of DXW. This centred on whether a claimant who had suffered a traumatic brain injury in an accident at work from fall from a roof in a claim against his employer should be told about the amount of his settlement. The claim settled for £6.6 million. The question was whether depriving the claimant of his right to know the amount of settlement would interfere with his basic common law rights and also his rights under the Human Rights Act to know the amount of settlement. But in this particular case, the court held that the claimant was so vulnerable from influence from outside that it was in his best interests not to be told of the amount of the settlement. And I thought this was an interesting case to raise. Particularly that it's important that if case managers feel that there is a risk to a claimant that you are working with, then to raise that with the claimant's solicitor prior to settlement of the claim so that we can look to try and pursue an anonymity order if needed. Next, I wanted to highlight three cases relating to consent. They're all very recent from this year. And they're all court of protection judgments. The first one held that it wasn't in the best interests of a young woman who was suffering from a chronic eating disorder not to be subjected to forced feeding as an inpatient, even though if she didn't gain weight, there would be a risk of her dying. The second case related to the court held that it was reasonable, that it would be reasonable and in the patient's best interest for her to donate stem cells to her mother, who needed the stem cells for leukemia treatment, because they held it was in her clear emotional, social, and psychological benefits for her mother's life to be extended. And finally, there's a case involving a patient with cervical cancer, and the court deemed that it was in her best interest to commence chemotherapy treatment. Next, I wanted to highlight a case from the end of last year relating to disclosure. And this is relevant because it relates to disclosure of case management records. It's a judgment of Master Thornett in the High Court. The facts of the case are that the defendant made an application for an extension of time to serve its care expert evidence. This was actually agreed by the parties, but the application went ahead because of the issue of the legal costs. The situation was that the defendant's solicitors had received disclosure of case management records less than 3 weeks prior to the time for service of the records of the expert evidence, and it amounted to a USB stick linking to with an internet link, and it amounted to about 6 lever arch files of documentation, including some old records and also new records, and records dating back to 2015. So it was an inordinate amount of work that needed to be done. Both the claimant solicitor and also the care agency were criticised in the judgment, and I've highlighted 3 paragraphs from the judgment, and I think the case really highlights the importance of case managers keeping good records and disclosing them in a manner that they're easy to read and understand. And also, it also highlights the importance of ensuring that there's good communication between the solicitor and the case manager in terms of the frequency and the disclosure and the manner of disclosure of case management records. Next, I wanted to give an update on accommodation claims. So many of you who may have attended our previous case managers annual seminars, you'll know that since the change to the negative discount rate in 2017, there has been an issue with claiming for the cost of the purchase of a more suitable property due to the claimant's injury, and why the formula that we are obliged to use no longer works. And I set out here and an example of why the formula no longer works with the negative discount rate. You may also be aware of the case of Swift and Gardner, which is the claimant had sustained an amputation injury in a road traffic collision in 2013. The case went to trial. It was agreed that she needed to move to a more suitable property, and it was agreed that that would cost £900,000, but she was awarded nothing for the cost of purchasing the property because of the negative discount rate. She did recover for the adaptation costs and ongoing running costs. This case went to appeal at the Court of Appeal on the 23rd to 25th of June. I've given you a link there in case you're interested in watching some of the appeal. Evidence was heard from a number of experts, including surveyors, valuers, economists, and actuaries. We are still awaiting the decision. When we had set up this webinar, we had hoped that we might have got the decision by then, but we're still waiting on it, and hopefully we'll have some news later this year. I also have wanted to highlight the case of Hardman. This is an interim payment application, and it just demonstrates the difficulty with making this type of application whilst the law on accommodation claims hasn't been decided, and Swift case is still ongoing. In this case, the claimant was seeking an interim payment of £700,000 in addition to previous payments of £104,000 with the intention of purchasing a property, a new vehicle, and to pay for ongoing rehabilitation. There was no dispute that there was a need for accommodation. There was a dispute over whether or not it should be a purchase or rental. The judgment just reiterates the need for the court to take a conservative approach when valuing claims for the purpose of an interim payment application. And in this particular case, the claimant was only awarded £365,000, which was the amount that the defendant had offered prior to the hearing, and obviously wasn't enough for the claimant to purchase the property. Then finally, I wanted to mention the case of Shannon and Rampasand. This is another judgment that we are still awaiting. It was a case of 2 appeals which were heard by the Supreme Court in February. The first was Royal Mencap Society and Tomlinson Blake, and the second was Shannon and Rampasand. Essentially, both cases were employment law cases on the application violation of the minimum wage. And both cases involve support workers who provided sleeping cover overnight. They received free accommodation, and they were effectively able to sleep, but were required to help if they were woken up during the night, which rarely happened. In the Court of Appeal, the court held that the workers were available for work rather than actually working, and therefore were not entitled to minimum wage. However, if the Supreme Court overturns that decision, then it will have a significant impact on the valuation of care for catastrophic injury claims, and we'll see an increase in the care costs. So that's the end of my slides. I don't know whether we have any questions. I'm going to stop sharing and bring us back to our screen.
No questions at the moment, Nikki, but I was just wondering, obviously one of those cases was very much about disclosure of records, and what's your view on how it works in practice and how records should be disclosed from the case management clinical perspective and the litigation?
So I just think it's important for the claimant solicitor and the case manager to have a conversation about manner of disclosure of records when the case manager is first engaged, in terms of frequency and what information is needed when. But in terms of the manner of the records, most records are now sent electronically. It's helpful to us if they're sent in a PDF, and that they're divided into sections, your correspondence, invoices, therapy reports, MZT minutes, etc., so that it's easy for us to review the records when they arrive, take out any duplicates of documents that we've previously seen. A bad example that I've had fairly recently is a care agency that has sent me records in, and each day is sent in an email, and it's sent in a zipped file to me, which means that we have to sort of open the zipped file, then open each care record individually, then change it to a PDF, and it just takes time and is just rather unhelpful. I don't know whether you, Warren or Claire, have any thoughts.
Yeah, I think one of the issues, my kind of tip really would be, when people are sending emails, there is a way to set a rule whereby instead of having the email follow on as a string, it's having the email attached, the last email, kind of attached as an attachment to the document, and that means that we don't have to read string after string after string of the same documents, because we do have to read everything before we give disclosure, and it can significantly extend the amount of time that we have to spend on cases and looking at that, the email strings if that rule isn't in place. So that would be my top tip or request, really, I think.
Most of the recent case management orders I've had, there's been an order for the initial disclosure list, and then there's been an order for rolling disclosure every 6 months. And obviously I've then made the case management company aware that we need the disclosure every 6 months, and it's just made the timings of getting the information much easier.
We just had a question in, Nikki, from someone in the crowd. How does the disclosure of records and subject access request records align as a disclosure of records for an ongoing request? I mean, I think both requests for records you'd expect to be dealt with in a similar fashion.
Yes.
The disclosure of records under the legal obligation through solicitor's office should be disclosed in a timely fashion, and with everything supplied. There's often concern about privileged entries potentially, but that's very much an issue for the solicitor to review, and if there is anything containing legal advice that's been given to the client, then that needs to be redacted by the solicitor. And I know that can become overly worrying for case managers to sometimes review their records and whether they need a separate folder for those to be kept. But all I would say is if there is anything that slips through, then don't worry, that is the obligation of the solicitor to review. So hopefully that deals with that point. Thank you for the question. If there's no further questions, I think we'll move on to the next topic. Thank you, Nikki. So my talk today is very much about practice and procedural changes in lockdown, as well as looking at the effect and the pros and cons of being in lockdown. There's been lots of webinars about changes since COVID and how we've all had to improve our operations, but I think really what I'm trying to look at is some tips and guidance for case managers that you may not have appreciated in terms of changes to the rules and how we need to do dealing with the litigation. Obviously, lockdown occurred in the middle of March and was reasonably unexpected, and everybody had to change their working practices fairly quickly to ensure that access to justice continued and clients' cases would still progress as they should do. Many of the clients we act for had cases all at different stages, either pre-proceedings or under court directions, and each required a different review of how we should be actively progressing the case. But certainly I think the whole business and legal world had to adjust to new working practices within their own home environment initially, and of course that was very different for each individual depending on what their own personal circumstances were. But I think we as an industry and a profession adapted very quickly to ensure that all of these cases could continue, and ultimately the clients weren't affected negatively as best we could. And certainly there was a concern that there could be a backlog of litigation cases, both civil and criminal courts, but the courts were very keen to ensure that that didn't happen, and certainly there were decisions early on that hearings and trials should continue by virtual means. And certainly at Stewarts, we had one of the first commercial virtual trials take place, the National Bank of Kazakhstan and others versus the Bank of New York. And I think that was quite groundbreaking at the time to have a full trial heard by a virtual basis. And obviously there was many practices that need to be put in place at the court in terms of video conferencing arrangements and all of the bundles for the trial to be electronic bundles. So there was a lot that needed to be done quite quickly. But I think Mr. Justice Tier was very clear that the courts they existed to resolve these disputes, and there was guidance given by the Lord Chief Justice, which was very clear that a default position should be that most hearings should be conducted with one or more than one of all the participants attending remotely. And certainly that's what we've had previously with some telephone hearings at the Queen's Bench Division of the High Court, but actually having some of the more lengthy trials or other hearings taking place by virtual video conference hearings is very different. There's quite a different arrangement that needs to take place for those. They can be more draining. You're having to concentrate more whilst focusing on the screen. As many of us know in this room, Zoom conferencing can be Zoom fatigue, they like to call it. You have to focus on the conversation a lot more, and there has to be clear focus that there's not discussion over one another. You also have to decide how to give instructions to the advocate who's representing the parties. If that's a barrister you have representing, normally you'd be able to pass a post-it note between you. Of course, that doesn't happen. So whether your instructions are provided via WhatsApp or text, that all needs to be agreed fully in advance to make sure that the hearing can go ahead smoothly. Often the judges will ask for the non-advocates to turn their cameras off to avoid distractions for the actual focus of the hearing. But we found that they do work smoothly, provided you've tested the IT and that each party has a thorough understanding of whether it's Microsoft Teams or Skype for Business, which seems to be the court's preferred mode of virtual hearings. But they have all been taking place. There's many hearings going ahead frequently. I had a lengthy interim payment application, but over the summer, and certainly, as I say, trials have been going ahead. So the courts will start opening up depending on the restrictions going forward, but cases will continue in the meantime. There's the Coronavirus Act 2020, which actually makes live streaming from the commercial court possible. And as I say, this continued in that case and has been extended to the other divisions of the court. There's also been some specific amendments to the court rules regarding COVID considerations during this time. Previously, the parties in a litigation case were able to agree an extension of time for the court directions of up to no more than 28 days. And after that, they'd require the court's permission, which can be lengthy, costly, and time-consuming to arrange on occasion, as well as having to provide justification to the court as to why you require longer time. Whereas now, under Practice Direction 51, the parties were able to agree extensions of time of up to 56 days during the pandemic itself. Now, that was due to ensuring it was compatible with the proper administration of justice, and that the court will take into account the impact of COVID. Obviously, there have been times when some expert assessments haven't been able to take place, or you've struggled to get instructions from your client or other parties involved in the litigation, or there's been people with health issues who haven't been able to take the case forward as they would have done. And of course, all of that has been relevant during the pandemic time, and the courts have allowed the parties to agree longer extensions than they would have needed. There's also been a change under CPR 5.3 that you obviously, this was in place previously, but you're able to assign documents by mechanical means such as e-signatures, which includes a statement of truth actually. So many of the witness statements we've been dealing with, or court proceeding paperwork, we've been able to deal with by signing electronically and with photographs of the client's signatures to be used specifically for that purpose with their consent. Obviously, during lockdown with restrictions on visitations, witness statements have been sometimes more difficult to do face-to-face. But on occasion, we've obviously proceeded by telephone and video conferencing as we would do. But from the 6th of April, there were significant amendments in relation to both statements of truth and evidence. And one new provision in relation to witness statements is that in the body of the statement, it must now include how the witness statement was taken, whether that was over telephone, face-to-face, or through an interpreter. And that's now required by law to be set out. So any case managers preparing new statements, you may see these new paragraphs inserted into the beginning of your statement, or if it is missing, it may be worth raising that with the instructing solicitor. And of course, the statement of truth in itself has become expanded to set out that you understand proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. So again, the concluding paragraphs of the witness statements prepared recently under Practice Direction 22 should all be following this format, otherwise they'll be not compatible with this current practice direction in place. I've undertaken a number of witness statements during lockdown. I mean, often we do prepare these by telephone meetings, and they've still been able to take place. I think you do certainly lose a lot of visual clues and guidance when speaking to clients and family members, and they're always much better taken face to face. But I think on the whole, if it's been a professional you've been working with for a number of months and you both understand the process generally, you're able to deal with any deficiencies in having that telephone and Zoom assessment for the witness statement. Obviously, settlement meetings have still been taking place during lockdown. They're either virtually by a video conference or telephone arrangements. And often we found that that can work quite well for the claimant because they're able to have that meeting in their own home and take breaks as and when they require, and there's no need for them to travel into the office or sometimes have hotel accommodation the night before. But of course, it has the opposite effect as well, that they're not in the room with you. You need to be very careful they're understanding your instructions and they're happy with the advice that's being given, and that they're fully on board with any offers and instructions that are being made on their behalf. I think also there's that lack of closure at the end of a settlement meeting, if it is successful, that they don't feel they're in the room with you, and it can all seem a little of an anticlimax for them. But other than arranging to meet in the future when COVID restrictions release, there's little to see how that can be overcome for the time being. But I think overall the benefits to claimants of feeling more relaxed with their family around them in their own home and allowing them to have rest when they need it during a settlement meeting, which can often be many hours over the course of a day, I think has found that that's quite useful, and you can still get very good instructions from a client who doesn't need to travel into central London necessarily. So I just thought it was useful here to set out a list of the pros and cons of how I see it's affected the way we work currently. I mean, it's clearly shown that litigation can continue on a remote basis, but we have had to adapt our practices. We've had to look at new ways of working. IT systems have had to quickly come up to speed, and we've all become experts on video conferencing and how to mute and unmute ourselves when required. So we've all done it. Everybody's also been having to work in their own way with their own personal family, work, school life scenarios going on around them, which has been tough and draining at times for many of us, but we've got through it, and we'll have to see how the next few months pan out as well. So it can go ahead. I think one of the disappointing features is that lack of personal connection and visual cues that you need to progress these cases and to tell the stories for our clients. Many of the home visits we would normally do with our clients haven't been able to take place. We are certainly on one of my cases, a client had recently moved into a new rental property because their pre-accident property was no longer suitable. And whilst I wasn't able to go and visit the property like normal, I've had a WhatsApp tour of the house. I've had a socially distanced visit with the mother in the garden. But I think that will be it for some time now, following the client being discharged from hospital. Each case has to have its own risk assessment of what is appropriate in terms of visiting going forward. And as the restrictions have become more enhanced over the last few weeks, I think that each case has to be considered very carefully. I think it's shown that there can be an increased accessibility of arranging multidisciplinary therapy meetings in a virtual setting, both on a clinical basis, but also experts for a legal conference. With nobody needing to travel and everybody having to find an hour slot in their diary for a Zoom meeting, we've actually found that cases can sometimes be progressed and things organised much quicker. But again, that's the lack of personal face-to-face discussion, where you sometimes miss the subtlety of key points that can be quite crucial in a case, particularly on, I'd say, brain injury cases, when speaking and understanding discussions with the litigation friend or the injured party themselves, it can be quite important that that is done face-to-face. And certainly there's some medico-legal assessments that were very difficult to organise initially. I'm discussing neuropsychology assessments, which I think Warren may be coming on to as well in terms of expert and case management. But also where physical examinations are necessary, it's very difficult to do an orthopaedic examination or physiotherapy examination over Zoom. You can of course direct the client to undertake certain movements, but ultimately a physical assessment will be what's required in the longer term. And what we found is many of these cases, it depends where the case is within the litigation. If you're still able to arrange a follow-up personal assessment in, say, 12 months' time, then that may be sufficient. If you've got trial looming in the next 3 to 6 months, then it would be depending on whether they've already assessed the claimant once already. So I do think that the parties generally are more readily available. That can also be a negative thing in terms of people requiring you to be available more often. And cases are being progressed quicker in some areas of the work, but there can be a real disconnect, I think, from the care team and support workers generally. I know many case managers are still doing personal assessments and visits to their clients with the correct risk assessment and PPE if necessary, but there's nothing that beats a personal visit to see your client rather than reading it in an email summary or therapy multidisciplinary review document. I think what it's shown as well is that many of the courts and the legal parties we were geared up for this already. There had been electronic court filing of documents for some time prior to lockdown happening, purely coincidental. So when we issue court proceedings now, all of the documentation is filed electronically on the court software and payments are made through that. But of course, any court hearings, we're now having to prepare PDF index bundles for the court, where there are very strict requirements on how they need to be indexed and hyperlinked, which can be very time consuming for our teams to organise, as well as we've all had to become very adept at the IT around having to arrange that. Costs, I think, will become more streamlined in some areas, particularly regarding arranging expert conferences. And that is obviously beneficial to the parties and being able to progress matters quicker. But equally, I think the cost and the cost budgeting process is an area where I think there may be arguments from some defendant parties that some of the personal visits could be done by video conferencing and telephone into the future, with a view to reducing the overall cost. Now, I'm still strongly in favour of you need to have that personal connection with many of these clients to tell their stories properly. And certainly in brain injury cases, that's even more so the case, where they may struggle with the IT and you're not going to get as true a picture by doing it all remotely. Even if you have the clinical and the care team on the ground reporting back to you, the legal team still need to understand fully what's going on. So I think the cost budgeting process generally is almost a pro and a con. Yes, there'll be some areas where things can be more streamlined, and I think certainly arranging many assessments has been really helpful, but equally I don't see it as reducing the costs overall into the future a great deal. JSMs I've already talked about. In terms, I do think it's been beneficial, the two I've done already in a home setting, with us and the council and the parties on a Zoom or Microsoft Teams conference link. But I do think there is a real sense of anticlimax and lack of closure for the claimants at the end of that process. I'm not sure how we go around that, other than, as I say, arranging something further in the future when we're able to deal with that, because often the clients at the end of the meeting have even been able to see the defendant team, the insurer or solicitor, who sometimes have come into the room to apologise for what's happened and wish them well for the future. And that is always something that's more difficult to do in a remote setting. Of course, there's also been some delays in both the Court of Protection applications and the system generally, but also the criminal process. So often if we're waiting for evidence from the criminal process in terms of needing liability evidence to take the case forward, we are finding that often these days that cases are taking between 12 to 18 months to reach a final hearing before we're able to obtain any of the police disclosure. So I think both of those processes, I think due to short staffs, due to people self-isolating or working from home and the processes being different, that will have a knock-on effect on how long these applications and sometimes urgent work that's required will be taking place. So I think there's been pros and cons of both. I think everyone's had to get up to speed quite quickly, and I know case managers have equally as well, and have been doing a fantastic job on behalf of all of our clients into ensuring their safety, as well as keeping them informed as best we can.
Excellent, thank you, Claire. We do have a question for you, and it is, despite the best efforts of the MDT to ensure that rehabilitation is provided swiftly and effectively to patients and clients, it's not always been possible to do that during lockdown. How do you think that will be viewed by the courts on assessment of damages? Do you think there'll be issues raised about it should have been, the delay shouldn't have happened, etc.?
Yeah, no, I mean, I think that's across the board, isn't it? All treatment for injured parties and those that are within the healthcare system are already awaiting operations and procedures. A lot of that is likely to be affected. And I think if there are additional costs or additional rehabilitation measures that need to be put in place in the meantime, that will all flow from the circumstances of their injury and their accident. We're all dealing with the same pandemic. This is not something, albeit this couldn't have been expected by the defendant, it's something that the claimant is having to deal with, and therefore should be able to be recoverable as a cost of the litigation. Similarly, I had an example yesterday of a client's brother being sent home from school due to potential COVID symptoms. And of course, the client with a severe brain injury needs to get urgently tested with her brother. and trying to arrange that at the moment is pretty tricky. And equally, if there are private tests that can be used and arranged, then I think the cost of that should be seen as a reasonable cost if it ensures that the client's rehabilitation or therapies can continue, rather than the family needing to self-isolate for longer. So I think there will be additional COVID costs, particularly in terms of also looking at any additional PPE that the client and her support team may need. All of that should be seen as recoverable under the compensation going forward, as long as it's reasonable and it's seen as a necessity for the rehabilitation to go forward.
Also, in the right case, it might be necessary to apply for a stay of proceedings if there's been a delay in claimant's treatment as well.
Absolutely.
Should I go ahead with my talk then, in the absence of any other questions? Well, good morning, everyone. My talk relates to where medical legal experts and case managers are regarding carrying out their assessment. Now, I'm aiming for 10 minutes with perhaps time for questions at the end, but we will be taking this at a bit of a canter. I do put you on notice. Well, I raised the questions of a number of experts in a variety of fields, including spinal cord rehabilitation, neuropsychiatry, neuropsychology, orthopedics care, and physiotherapy. Now, we'll put the questions up on the screen so you don't have to look at my ugly mug all the way through. Now, we'll take the questions at a bit of a pace, but question one, have you returned to face-to-face meetings? Well, there was a resounding yes to that. So what steps are being taken to protect their and your safety at the assessment? Well, those working within the NHS are already used to those routines set out by Public Health England and the guidance they've produced. So they're already comfortable with that. The usual pre-COVID risk assessment when arranging the assessments, and then a call 24 hours beforehand just to make sure that there aren't any emerging COVID symptoms. The experts and the patients should seek to avoid public transport when travelling to the assessment. Finding an appropriate COVID-safe venue and avoiding COVID risk areas. But as we know from this virus, those do change very quickly. The neuropsychiatrist, he has fortunately a large consultant room, so he's happy to share that with his patient, client, and remove masks if the claimant is necessary. However, the orthopedic surgeon approaches it differently. He has two rooms, one for the claimant to complete a questionnaire and then give an oral history taken by telephone, and then the claimant joins the consultant in a consultation room for the actual assessment, thereby keeping the face-to-face time to a minimum. At the meeting itself, infection control measures are all explained, as is the use of PPE. Physiotherapist said that she always tries to keep her assessments now down to 20 minutes and always outside where possible. The care expert makes a point of always changing clothes after each assessment. I think the general thrust was consider whether face-to-face is necessary and appropriate, and do it as long as the benefits outweigh the risk. Question 3 was, do you consider any that virtual assessments are here to stay, and the pros and cons? Again, yes, but they're not a substitute. The spinal consultant, he was concerned that he was unable to carry out neurological assistance effectively, especially with those with incomplete injuries. He finds it difficult to identify if there's exaggeration or there's understatement of disability. The neuropsychologist, it's difficult to observe effort, executive function, and neurobehavioral features. The neuropsychiatrist picked up on patients being more comfortable in their own surroundings and highlighted that virtual assessments have been taking place in Australia, Scandinavia, and Canada for many years. The orthopedic surgeon sees a definite place for virtual assessments only in very simple cases. But where the injuries are more complex, perhaps limb, joint injuries, then an examination is always going to be needed. The care expert identified that it's quick and easy, but that more due diligence needs to be carried out to get an effective history and a full history from the patient. Sometimes the patients don't really like to give that the first icebreaker Zoom assessment, so a second is needed and then a follow-up at home. One of the big benefits for the care expert was being able to join the lead medical expert in the assessment, so that if there are any tricky issues such as double up care for transfers, etc. It can be discussed there and then at the assessment rather than, many months later in consultation with counsel. I think for lawyers, this will become a battleground in the future, and we're going to need reasons to justify some face-to-face appointments. Fourth question is, what factors do they take into account? Well, patient preference. Older people may be less willing to engage on Zoom, as may be those with hearing, vision and communication problems. There's also the expert's preference. If there's a significant disability, if there's a complex presentation, they're going to need to go out. In fact, the neuropsychologist, he defaults to face-to-face and only goes to virtual if face-to-face is significantly contraindicated. The orthopedic expert, well, it comes down to a complexity of injury. The care expert really takes into account what's going on in the area where the client's going to be, what's going on there in terms of COVID. She also highlighted, well, what's the solicitor's preference? Is there a deadline that the solicitor and the courts need to work to? The primary factor, however, that emerged was safety for the patient and for the expert. Whether the experts would be at a disadvantage if they hadn't assessed in person, but their opponent had, well, yes, was the general feeling, particularly those who carried out the hands-on assessments, so the orthopedic, spinal cord, but also the neuropsychologist. They were concerned about allegations of, well, was there a poor quality connection on Zoom? Was there anyone else in the room, and how did you make sure there wasn't? It'll be interesting to see how far challenges by opposing counsel will go and how far the courts will let it go as the cases roll out. Lessons learned about the role of experts. Well, one expert commented, it's a logistical nightmare. However, the other said, well, appointments, MDTs don't need to be cumbersome things. Letters, travel to London, assessment rooms, etc. They can be sorted out much more swiftly, but assessments generally do take longer. Technology can be intimidating, but if the client's comfortable using it, they will be more comfortable in their own home having the assessment. And it's certainly beneficial for those with cognitive fatigue, mobility issues, etc. Anxieties are reduced, and this improves the assessment process. One expert commented, I think probably like us all, that he's still learning about his role since the onset of COVID. So that's experts. Moving on to case managers. If you can change the slide, please, Josh. Similar questions. I approached case managers from relatively small companies to national companies, and I received, the ones I approached, 5 responses. So again, we'll go through the questions. In relation to returning to face-to-face meetings, 2 had continued with face-to-face throughout, subject to the risks being properly managed and there being a clear need for their personal attendance. 2 have returned as lockdown has eased, and 1 hasn't had a need to return to face-to-face yet, although some of our colleagues had. The general feeling was that face-to-face should be kept to a minimum and only take place where necessary at present. The steps taken to protect their and the client's safety, well, social distancing, risk assessments are a must, as is adequate PPEs you'd expect. But it's not just to take into account the case managers and their clients' needs, it's also to take into account the support workers and any others in the home. Never more than 1 meeting per person per day, changing clothes and washing the dirty clothes when they return home. Client meetings taking place in gardens, case managers carrying their own folding chairs in the boot of their car now, and giving support worker supervision while walking around lakes are all examples of innovative ways of providing your services. Opening windows in home assessments when you can't do it outside, not carrying unnecessary items. One case manager foregoing the use of her handbag, but I do caution you to bear in mind that if you're carrying papers relating to your client's medical condition and personal data, be careful not to leave them in your car because of GDPR. Ultimately, respect the client's wishes if they decline face-to-face meetings. Are virtual assessments here to stay? What pros and cons? Again, yes, the convenience, cost, ease of arranging for the client and case manager being mentioned by all. The engagement problems caused by fatigue and distractibility can be reduced by having multiple Zoom meetings over the course of a short period. However, Virtual is not as good as being there. Clients, we all know they've been through horrific situations, and the case managers recognise the need to give the personal touch, missing out on body language, reactions to client and family when the rehab package is discussed, and revisions to it are suggested are really important. It's difficult to tell how much a client is observing and environmental difficulties that the client's facing, although one case manager managed to arrange for her mobile client to give them a virtual tour of her home using their own mobile phone. But ultimately, it's a case of not getting the full picture that's the concern. The factors to take into account when deciding whether to perform the assessments virtually or face-to-face, well, the COVID risk. Do I need to be there? Client insight into COVID and their issues, and the communication difficulties that client may well have. Does the client have access to tech, and do they understand how to use the tech, or do they have support to help them? One case manager mentioned, interestingly, that if a client has been hospitalised over the course of COVID and they've had very little support from their family, well, will a face-to-face meeting give them a psychological boost from their case manager? I thought that was quite an interesting point. I asked whether there are some classes of clients that are unsuitable for virtual assessments. Well, acquired brain injury, children, they're the most difficult to engage with virtually, but also mentioned were those with significant speech impairments and those with social cognition issues. Question 6, whether INAs conducted remotely have been as effective. Well, there is a general feeling that no, they haven't. They're a good filler, but for the reasons mentioned above, they can't replace face-to-face. I think one case manager captured it by saying, well, it's better than phone, but it's not as good as being in person. What lessons have been learned about their role as a result of COVID? Well, some clients cope better than we think, and some less well. How much they rely on us as case managers for practical and emotional support. Be flexible and adapt to your client's needs. One case manager mentioned recognizing her reliance on other therapeutic services in order to deliver the full rehabilitation package. But ultimately, communication is the key for the MDT and the client. Now, I expect this comment to speak for a lot of you out there. One case manager said, I'm a people person. I love my job because I love spending time with my clients. Not being able to do that was tough. Lessons learned during lockdown and how they're going to affect the way they work. Well, it's unanimous that face-to-face contact would reduce in future, and the use of virtual meetings where appropriate would increase. It does give an opportunity to work with a wider range of therapists as long as it's appropriate for them to deliver their services virtually. I think the last word goes to the case manager, who advised us all to prepare for all eventualities in this new COVID world. So thank you very much to all of the experts and case managers who responded to me. I hope that wasn't too much of a canter. If anyone would like to see my script, basically my summary, then please do email me and I'm happy to send it out. But that's it done for me. Thank you. Unless there are any questions.
Thank you, Warren. I can't see any questions so far, but I've got one for you. What impressed you the most from the answers that you received from case managers?
I think it was the can-do attitude and the way they have adapted to answer the challenges thrown at them and their clients by the COVID situation. Lockdown walks in the parks, giving supervision to support workers. Virtual tours of houses, just managing to be there when the clients have needed them despite the lockdown. I think that's really impressive. The therapeutic services that have been ongoing. And I guess, I don't know about you guys, but I know that some of my case managers have had real problems working with their care teams because, you know, the support workers themselves, they've got families, they may have people at home who are vulnerable to COVID, etc. So managing to keep the wheels on the bus really has just been hugely impressive, and the way that come through in the questionnaires, yeah, definitely. What about you? You guys must have had some experiences too.
Yeah, I would echo that. I mean, I think the tremendous amount of work that people from all areas of our practice have had to put in to ensure that, you know, the wheels don't fall off of these cases and the clients' rehab packages. As I say, because everybody is available more often, everybody's been tremendously busy, and I think that that's a credit to everybody, that we're trying to keep the clients at the heart of what we do and ensure that they're protected, whilst at the same time everybody's have had a lot of things going on in their own lives as well. They've been trying to juggle, and everybody's become an expert at everything, to try and you know, keep things moving for people, and that's what I've been impressed with.
Got two questions. At the moment, most clients in care homes cannot have visitors unless it's essential, so are missing out on therapies as well as crucial family visits. While it's imperative to safeguard their health as time goes on, we're seeing different deteriorations as a result. Where do you see this going in the future?
Is that in relation to the actual litigation claim, or do you think?
I think from a clinical perspective, I mean, I think there will be some instances where the client's rehab has suffered a setback, and it may well have affected the length of time the case needs to continue, or the length of time they need to continue receiving treatment. And that is likely to have had an increase in the costs that we'll be trying to recover on their behalf. I think there's practical considerations as well as the legal considerations in terms of the quantum value that we'll be looking to try and succeed. I think, you know, there's difficulties all around and everybody's working the best they can. Ultimately, if therapists are not able to go in and do personal assessments, then Zoom or telephone input has to be the second next. It's not the best, but the second next route in. And we'll have to just carry on with that for as long as personal visits are then allowed back in. But I think if there has been any increase in deterioration or additional equipment or future treatment they'll need as a result of that, then we'll be trying to look to recover that on the client's behalf. That's all we can do at this stage, I think.
And there's another question, it's for me. If the court agrees for staff to be paid minimum wage when they're sleeping, would there be a backlog of claims which could affect settled and new claims? I mean, it certainly will affect claims that are ongoing, because if that decision is made, then it's going to increase the care costs. And it no doubt is going to affect claims that have already settled, because care costs are going to increase beyond what was envisaged, and there may well be a shortfall for those claimants.
I mean, I think that's probably where we're going to see the benefits of a periodical payment order. If your client has a periodical payment order in place and it's linked to ASHE 6115, that should keep up with carers' wages. But for those who've settled on a lump sum, it's going to be a difficulty for them.
That's difficulty with any stage, that you can only deal with the law as it is at the time the case settles, and similarly there'll be other issues surrounding accommodation claims whenever that is resolved with Swift and Carpenter, and we do have to just keep watching this space to see what that happens. But often you find that cases can be negotiated and resolved taking practical considerations into account, and it depends on the insurers you're dealing with whether they're prepared to look at the case in the round. But I think that's the last question, is it?
Yeah.
So I'd just like to finish by saying thanks to everybody for joining us today and listening to our seminar. Unfortunately, we weren't able to hold the annual conference we normally do, but hopefully at some point in the near future, we'll be able to see all of your faces again in person. The lucky winner of the Magnum of Champagne is Eloise Fletcher of Rehab Direct, who was randomly selected, and we'll be sending that over to you if you'd like to let us know where's the best place to send it, Eloise. If you send me an email, we'll arrange that as soon as possible. We will be arranging further webinars, both our team directly for case managers, but also there's an expert training day coming up on the 23rd of September, looking at what lawyers want and also what experts need, and that's hosted by Nick Knowles, a partner in our clinical negligence department, and Gerard McDermott QC, and Mike Hayton, who's an orthopaedic surgeon. There's also some further case manager sound bites taking place, which are short webinars. And the next one of those is the 30th of September, which is focusing upon Dr. Donald Brecken, who's a neuropsychologist, giving his thoughts on the current scenarios he's dealing with. So thanks for everyone for attending, and we wish you all well and stay safe for the future.
Thank you. Bye, everyone.